for everyone coming. This attendance is awesome for our first webinar of the semester or for the academic year. We are APSA Law and Courts, and today we're talking about the court's new term, what's coming up, and all sorts of questions that you may have. So feel free as we have this conversation together to drop your questions in the chat. And especially a warm welcome to all the students in the chat here. It's really awesome to see some blooming political science scholars getting involved with these conversations. If you are a student, if you could write your name in the chat and just introduce yourself, that way we can connect y'all all together at the end here. So we're joined here by our moderator, Christine Bird from Oklahoma State University. We have Nathan Carrington from St. Louis University, Tim Johnson from the University of Minnesota, and then Steve Vladeck from Georgetown. So I will hand it over to Christine, unpin myself, and we can let the conversation begin.
Okay, well, again, welcome everyone. I see a lot of my own students in the list here, which is great. Good for you. I successfully bullied you and bribed you to come. So thank you to our panelists for joining us today. We have a lot of expertise in the room, and today's panel, we're talking about what's happening at the Supreme Court this year. So these are experts who know a lot about the Supreme Court, what happens at the Supreme Court on the merits docket, and we're going to talk a little bit about what to expect and what cases to watch. And especially if you're in my class, you have an assignment to follow a case. So if you find something interesting here, you can still change your mind. So we'll get started with the overarching question, or what are the big cases and issues that you guys are watching this term? And also at the same time, we can talk about if there's any cert petitions you're watching or cases in the proverbial hopper. And I'd like to start with Nate.
So thank you for having me, and thanks to Shane, Rachel, and JB for organizing this, and for Christine for moderating. There are a couple of cases that I'm really interested in this term, particularly the one Free Speech Coalition versus Paxton, which is the First Amendment free speech case out of Texas, where the state sort of, well, they did ban, they made it such that you had to have an ID in order to access pornographic websites. And the Fifth Circuit sustained that law by applying rational basis review. And so I'm interested to see how the court responds to that. And then also there was a new Fourth Amendment case today, Barnes versus Felix, that was announced that I'm pretty interested in seeing how that unfolds. I don't really do a lot of stuff with Fourth Amendment, so I can't shine too much light on that, but that is a case that I'm interested in as well.
Great. We'll move over to Steve.
Thanks, Christine. Hi, everybody. Let me apologize in advance. I've rather lost my voice unrelated to rooting for the Mets the last couple of days. So I guess I want to sort of pour a smidge of coolish water on the court's upcoming term, at least as we have it so far. So with 13 cert grants this morning, that gets the court to a total of 43 cases. There are 3 consolidated cases, so it's really 40. My sort of top line reaction is just about none of the 40 hold a candle to the highest profile cases the court decided last term or 2 terms ago or 3 terms ago. There's ghost guns. There's the Glossop versus Oklahoma death penalty case. There's Skirmetti, which is obviously a really important sort of first opportunity for the court to talk about what, if anything, the Constitution says about discrimination against transgender individuals. But even with today's grants, there aren't really like super high profile constitutional cases. There aren't like nationwide policy fights. And so I think really, at least to this point, the story of the term is a bunch of like lawyerly fights over legal procedures and statutes that have, sharp ideological valences, but not the same kind of public appeal. But there are 2 critical caveats to that. So the first is, this might be news, but I hear that we're about to have an election. And it just seems almost inevitable that the court is going to be asked certainly to weigh in on emergency applications in the run-up to the election, as there are challenges to late shifts in voting procedures or claims of irregularities. Um, and depending upon the result, if it's close enough in a small enough number of states, I think it is entirely possible that the election itself ends up in the Supreme Court, at which point the theme of the term will very quickly become the election. Much like the theme of last term turned into really Trump in a way that it would not have been clear on October 4th. So, I think it's very possible that this term ends up being about the election. If somehow things go in a way where the court is able to duck the election, and there are lots of reasons why I hope that's how things go, I think we're in for a relatively modest term where there are going to be some really big administrative law cases and some big regulatory fights. And there are a handful of cert petitions coming about lower court decisions invalidating delegations of power to private entities, for example. But Christine, in the broader scheme of things, I think it really is not, at least where we are today, set up for the same headlines every day. So caveat number one is the election. Caveat number two is, this is my particular bugaboo, but the court also, even in non-election cases, keeps doing more and more big stuff through not merits decisions, not its merits docket, but the emergency side of its docket. And indeed, right before we had this call today, we saw two big rulings in environmental law cases come down through unsigned, unexplained orders. So, the caveats to me are, one, we don't know what effect the election is going to have on the term. And two, it's increasingly the case that some of the most important stuff the court does is late-breaking stuff that happens on the emergency side of its docket, which is also really hard to predict in advance.
Great. Could you briefly explain the difference between the merits docket and the emergency docket?
Sure. So we're used to thinking about the Supreme Court through its merits docket. Those are the cases we read. Those are the cases we assign and we teach from. Turns out the merits docket is really a teeny tiny slice of what the Supreme Court does, right? About 1% of the dispositive orders the court hands down in any year are in merits decisions, by which I mean cases that are briefed, argued, and then resolved through like long signed opinions with concurrence and dissents. Most of what the court does is through unsigned, unexplained orders. And by volume, I think a lot of you guys know most of that is granting or denying certiorari, agreeing to take up an appeal. But emergency relief is when a case has not yet reached the Supreme Court, but the justices are asked to adjust the status quo while the litigation works its way up to the court. The court has had the power to grant emergency relief, at least expressly, for 99 years now, but it's really become a lightning rod in the last 10 because the court has started using that power in contexts and with sort of real world effects that we had not seen until really the mid 2010s. And that's part of why, it used to be sort of almost all death penalty cases. And now it's, general regulatory cases. And it's part of why, to me, right, we have to be careful when talking about the full Supreme Court term to include this other less visible stuff that the Supreme Court does.
Okay, thank you. I think someone's written a book on that recently that you can find on.
I have concerns about the author.
Okay.
I hear weird things.
Okay, the joke for the students in the room is that Steve wrote the book, so we'll talk about that more in class later. Tim, what are your cases to watch?
Yeah, I think I'm with Steve that the blockbusters are not there yet, although the court has already, as to one of his caveats, delved into the election so far, right? In an emergency petition out of Arizona. I was going to wait and talk about this when you ask about the election. The court has upheld, in an unsigned opinion, Arizona's power to make people prove their citizenship in order to register to vote. And so the court has already stepped in, and there are cases as Steve also alluded to that are percolating up through the system that could get to the court that may not be about Harris versus Trump necessarily, but may very well be about redistricting or other issues that would then inadvertently affect the presidential election. I guess not inadvertently, probably directly affect them, if you will, because they are about who may vote and who might not vote in particular states. And I'm sure we will get to that. But there are a couple of cases that I would talk about. I like Steve's broad overview, and I agree with Nathan on the idea of the free speech case. I'll make two comments. The first is, at least so far, It is possible this is will be the second straight term where the court will not take either a religious freedom or an establishment clause case. They are not docketed yet, and that is very unusual for the Roberts Court because this court has been very friendly to freedom of religion. In fact, expanding it to a greater extent than I think it's been expanded in decades. And I probably don't mean that all the way back to 2005, the entire 20 years of the Roberts Court, but probably in the last 8 to 10 years. And the court has also really sort of, in the praying football coach case, sort of turned establishment clause jurisprudence on its head and said, we're really not going to look at establishment clause as establishment clause cases anymore. We're going to really turn them in to freedom of religion cases, which really is expanding that freedom. And then to have the court turn around last term, and at least initially this term, not docket any of those cases, I find sort of unusual. But I'll just point out a couple of cases that I find interesting. The City and County of San Francisco versus the EPA, I think is going to have the court go back and continue to hammer home at what it did to the Chevron doctrine last term in terms of whether or not generic prohibitions on clean water are something that can then be interpreted by the EPA. And I would expect that we all at least can predict pretty easily what the outcome of that case will be. And I'll have a little bit more to say about that with one of your other questions, Christine, for me. And then I am also, and very strangely, didn't think that this would be a case that would come to the forefront for me, but Royal Canin USA versus Wolschliger, I'm interested only because this is a very clear federalism case. The specifics in this case are about whether or not a party can amend their complaint in federal court to actually, that is already in federal court, to remove all references to federal law to force the case back into state court. And this is a concept that goes all the way back to the early 1970s called New Judicial Federalism, when then Justices William Brennan and Thurgood Marshall were trying to force cases back to states, or actually try to convince litigants not to bring cases to federal court because the federal courts, as they are today, were much more conservative than the state courts. And so we've come back more than 50 years later, just about 50 years later, to litigants, lawyers, and I will bet some lower court, actually probably Supreme Court justices, hoping that cases can stay in state court so that they don't come to federal court with federal issues and set pretty conservative precedents, as obviously the Roberts Court is wont to do. So that's sort of where my eyes are right now on the current term.
Great. So all of you have already spoken a little bit about the context of an election year. I'd like to hear, do we think that the Supreme Court finds itself constrained by the election year? Is it reacting to the election year? Is it constraining their behavior in any way? So besides election cases being on the docket, how are they going to think about this election year? And we can just go the opposite direction. So we'll start with Tim.
So I'll say that I think that the justices already thought about their role their role of constraining their voice. The justices constraining their voice in an election year, and that had to do with the 2 reproductive rights cases that they decided at the end of last term. There was no way that they were going to have a repeat of Dobbs first May and then in June of 2022, whereby they really activated a large portion of the liberal electorate that really stopped that red wave from coming, and it turned out to be a pretty decent blue tide, if you will. And in both the Moyle case, as well as in the Mifepristone case, the justices really punted, right? And the Mifepristone case probably won't ever come back to the court. I think the argument that Kavanaugh makes in that case, there's no one who will probably ever, and I should never say never, but I'm not sure anyone will be able to prove they have standing to bring Mifepristone back to the court. Perhaps there's a lawyer who is incredibly brilliant and can make that argument. On the other hand, I think Moyle comes back, and I would not be surprised if once the election is over, that the when the case is decided back in the circuit, that case comes back to the court pretty quickly after the election, maybe not docketed for the end of this term for oral argument, but maybe docketed at the end of this term for arguments next term. So I think the court has already been involved in thinking about its role in terms of trying to be quiet. And maybe that's one reason, as Steve pointed out, that the court has had a quiet docket, at least so far. The other part of it might be that the justices simply know that the docket's going to get less quiet very quickly as we get towards election day.
Okay, Steve.
Um, I agree with everything Tim said. I would just add, um, I think besides cases, I think the other way that the election is hanging over the court is what kind of government they're going to face come January. Um, and I mean that both insofar as who's in the Oval Office and what does Congress look like. Um, it really, if you talk to folks on the Hill, I think that one of the things that Democrats have been talking about a lot is that if Democrats retake the House, which certainly seems within the realm of possibility, um, you're going to have much more aggressive investigations into the court by the House Judiciary Committee, which will have subpoena power, and will not have to deal with the Senate's complicated, political sort of compromise accommodation norms, right, when it comes to subpoenas. So, even a Democratic House could mean a much bumpier road for the court when it comes to that. Um, I think a court that has a sort of a President Harris is probably not going to view its role as shifting that much. It's going to look a lot like I think it currently views its role vis-a-vis the Biden administration. Um, but a court in a second Trump term, I think, is going to be in a very interesting and I would say awkward institutional position where, I don't think I'm speaking out of school to suggest that there are, not all six of the Republican appointees are going to be on board with the Trump agenda, but where they might be very concerned about their ability to really stand up aggressively to President Trump, versus their ability to stand up to a Biden or a Harris. So, I think the election's going to loom hugely over the court, even if it is somehow able to avoid all election-related cases, not just in driving what the court's next couple of terms look like, but in driving the court's institutional relationship with the other branches over the next decade.
Great. Nate?
Yeah, unsurprisingly, I agree with everything that's already been said. I would just add to Steve's point that perhaps if the GOP takes over the Senate, we might see increasing talk of retirement from particularly Justice Sotomayor. There's already been that pressure among Democrats to sort of, in hindsight, seeing what happened with Justice Ginsburg, to try and ratchet up the pressure for to get younger Democratic appointees on the bench. But I would also say that in addition to the context of what the court is doing in this election year, I'm also interested in seeing how the justices individually participate around the election in this time of year. And so, for example, we've already had Justice Gorsuch make some comments whenever he's given interviews, for example, warning Biden to be careful when it comes to like court reform. Justice Jackson raised eyebrows with comments that she had said about like sort of talking about the historical nature of Vice President Kamala Harris's campaign. So I think all of this is definitely in the forefront as we go into the election. And I would just say that going back to something that Tim said, it's very hard to tell whether or not the current quietness of the docket is because of the election or also just because of the public support for the court kind of dropping quite a bit recently. And we'll talk about that more a little bit later.
Okay, great. So we're going to move on. I have individual questions for each member of the panel, and we'll start with Steve. Have you noticed that there are any differences in how lawyers are preparing for oral arguments now in the context of a 6-3 court versus the 5-4 court that you've argued before? And are there any new players, any new lawyers we should be watching out for?
So I think there's sort of two different things going on. It depends on the cases, right? There are the cases that don't neatly line the justices up into their ideological camps, where I think, there's still a lot of effort being put into figuring out how to build coalitions across the court. So, I think there are a number of lawyers who are targeting cert petitions in criminal cases to like a Gorsuch-Sotomayor combo, and trying to appeal to like the libertarian streak that they have in common in a lot of those cases. I think there are contexts in which there's sort of the nerdy, non-ideological at all cases where people are trying to appeal to the, sort of the, I don't know, the theory heads on the court, right? So more like the Kagan, Chief, Barrett cohort. right, than maybe Thomas too, right, than sort of the more pragmatic judges. But I think also, man, there's a lot of effort to try to figure out Justice Barrett. And I think, last term especially, she really showed, an independent streak. I mean, independent of what is a messier question, Christine, but certainly that she is not as predictable, even in ideological cases, as we might have thought. That there are sort of arguments she won't buy, even when they line up with what we think her preferences are. So I think even in ideological cases, there's an effort to sort of try to, steer arguments that toward her, and things that might pick her off. With regard to lawyers, I mean, there are there's some really interesting plaintiff side work being done in nerdy procedural questions. So, Deepak Gupta and his firm Gupta Wessler got another grant this morning in a case that like you wouldn't have thought this court would be interested in ruling in like taking up. Sort of, finding ways to make procedural rights interesting to the conservative justices. Maybe because the plaintiffs aren't the obvious ones, maybe because the defendants aren't the obvious ones. I think there's a lot of that going on. And last, and I think this won't surprise anyone, I think there's a lot of effort to keep cases away from the court. And whether that means not bringing them in the first place, maybe that means not appealing losses in the courts of appeals. The total number of paid cases is only down a little, but it's down. And I don't think it is down in a way that is ideologically symmetrical. Right. And so what that suggests is that, people are reacting to the court we have. Just one last thought on that, of the 13 grants this morning, 3 or 4 are from the Solicitor General. And that's interesting in 2 respects. One, those are cases that might go away, right? If President Trump is reelected come, November and comes in office in January. 2, I think when we look back, we are going to be very surprised at and impressed by how well Solicitor General Prelogger has fared in this court. I think that office has done a really interesting and, at least to my mind, remarkable job of picking the right fights, and of choosing when to like go to the court and when not to. And we're so conditioned to think that everything is partisan these days. I think she has a lot of credibility, even with the justices who are not inclined to agree with her, that, she knows what she's doing and that the government's not just sort of, how do I say, trying to take advantage of the court. And I think that could matter. Maybe not in the cases that were granted today, none of which are like massively important, like, life-altering cases, but certainly if we get into some kind of election-related dispute between now and January.
Great, thank you. And we'll go back to Tim. Are there any upcoming cases where you expect a particularly interesting oral argument?
Yeah, so I love this question, and I've got a couple cases that I'll point to that we've all talked about, but I just want to pick up on Steve's final point, and that is I want to point out in particular to you all who are taking Supreme Court process courses from Christine or anyone else who's from Nathan or from me or anyone else who's in the chat right now, and that is that we know that the Solicitor General, as far back as World War II is sort of when we do most of these analyses, has always had this place at the Supreme Court where they are respected even when a court is ideologically divided from the Solicitor General. And so they get that sort of play. And I think Steve is spot on to point out that this SG office, I think, has done probably as good or better job than any previous SG office in the past couple of decades in picking those cases, right? It's not that you're always picking the cases in an SG that you think you're going to win, but you're picking the cases to make sure that you're not sending signals that you want particular ideological outcomes or signals that might harm law in ways that you don't want it to be harmed, when you're just trying to play a separation of powers game in some sense with the Supreme Court and the administration. But that wasn't the question you asked me, Christine. So let me go back to 3 cases that we've all talked about. I think because research shows, not only mine, but folks who've studied oral argument over the past 3 to 4 decades, that given that oral argument is the first time the justices quite literally speak to one another about a case, they hold very strongly to this norm that they will not, even when they're voting at conference on cert, they don't talk about the merits of a case. The first time they're going to talk about a case with one another is at oral argument. So, for instance, in Scrimeti, I think we're going to get the first time that the justices are going to really be talking in a very explicit way about whether or not to give equal protection rights to kids. The court has never spoken on the idea of giving equal protection rights to children. And this case specifically out of Tennessee and Kentucky is about whether or not gender affirming care can be banned for people who are under 18. And so I think you're going to get this interesting debate among the justices, not only about applying equal protection to citizens under 18, but I think we will see for the first time, hopefully, I think, a discussion about what sort of test they're going to employ, right? If you start seeing the 6 or some semblance of the 6, 5, or all 6 of them talking about employing rational basis, then it perhaps it's pretty easy to guess who's going to win that case, because it'll be easier. It's an easier argument for a state to say, we just need a rational basis, and that is to make sure that children are not abused, to allow these bans on gender affirming care to stand. If, on the other hand, they go down the road and you see, possibly a Barrett and a Kavanaugh supporting the idea of some level of heightened scrutiny for transgender people, then that might lead you to predict a different outcome. I don't expect that to happen. I mean, the court is very reticent to make any sort of quasi-suspect class that would give a special level of scrutiny. But I think that the debate that you're going to see between the two sides in terms of equal protection and kids will be interesting in Scrimeti. I think in the EPA case, it will be the first time that we will see the justices speak publicly with one another, and perhaps to one another, or even against one another, on how far we're going to go with Chevron being overturned. So that, I think, will lead to some interesting debates, both in both parts of oral argument that we have today, because oral argument is essentially broken up in some sense into two different sections, one where everyone gets to speak in order of seniority, and then you go back to the old school pre-COVID freewheeling. And then finally, because I've already spoken about it once, I'll be very quick about the Walschlager case. I think to hear this court and these justices, who we have 6 very, very strong states' writers on the bench, maybe not as strong as the court was on states' rights, sort of mid-1990s Rehnquist court, but certainly we've got some very strong states' writers, and to see them stand or sit, I suppose, in this case, with questions and with comments about where and what power states should have, and where and how you can keep cases coming to the Supreme Court or into federal courts more generally, will be an interesting debate to see. So I think it's those 3 where you're going to see probably not fireworks, right? Because none of these, although Scrimeti probably is, the 3 are not high fireworks type cases, but I think you may see some pretty interesting discussions between the 9 and the other 2, the attorneys who are in the room, while they have oral argument in these cases.
Great, thank you. So before we switch over to Nathan for our last planned question, just remember, if you have questions, you can drop them in the chat. You could probably go ahead and start doing that now so we can collate them while I ask Nathan this incredibly important question. You spoke about public opinion earlier. I would love to hear you talk a little bit about the research that you do and how you see leaks and scandals at the Supreme Court. How is that playing in to how the court does its job? And do you expect the court to respond to those patterns in public opinion?
Yeah, Christine, you're exactly right that this term is kicking off in the context of a lot of scandals and leaks. And I think that those could matter in both directly and indirectly. Indirectly, it's really going to affect how the public views the court. The public doesn't generally care about leaks per se. They are more interested in what the outcomes are at the court. And when it comes to scandals, it's really going to depend on how well the parties and the partisan elites keep the focus on that topic. But directly, I think that these leaks are certainly going to affect the way the court conducts its business. And we sort of saw this last term with how slowly the court was churning out opinions. And there was some speculation that that was in large part because of some of the internal procedures that were changed following the leak of the Dobbs opinion to try and prevent things like that from happening. I also suspect that part of, and this is pure speculation, but these leaks have taken place over multiple terms, which sort of hints to me that this is not a clerk that's doing the leaks. And I don't want to say that a justice is the one that's leaking it, but the evidence seems to support that argument. I'm not going to accuse anybody. But surely that affects the internal dynamics of the court and the way that the collegiality, and we've sort of seen some of that come through with some of the public comments that the justices have made, and also the reporting by Joan Biskupic. I don't know, again, her source is incredible. The stuff that she reveals are things that really only a justice would know. And again, because the leaks have happened over multiple terms and, clerks are termed out. I don't think that it's a clerk doing it. Now, as to the second part of your question, how will the court respond to this decrease in public opinion? That's an interesting question because the court is not behaving like we would expect the court to behave if it were losing its support. So historically, when the court is on the brink of losing its support, it sort of moderates its behavior. It might throw a policy win to public support. So rule in ways that the public likes. It might just sort of back off for a little bit. And maybe that's what we're seeing, because earlier we were talking about how there are really no high profile cases. So it could be that this term is the one that we're seeing the foot let off the gas. But up until now, this court has continued to take on highly salient cases that maybe they didn't have to. They are deciding controversial issues on the shadow docket. They are deciding cases much more broadly than they arguably have to. And then they're also using or discussing in the public things that they probably would not before. And so I think this really raises an interesting question about who the justices view as their constituents and why are they doing this behavior. And so if we think of the court as needing to maintain public support, then we would expect it to sort of take the foot off the gas, maybe, rule in favor of public opinion every so often to sort of replenish its reservoir of goodwill. But if we think that maybe the justices, or particularly the majority of the justices, the Republican majority, is viewing Republican elites as their constituency, or maybe Republican justices or judges, lower court judges, things like that, then that can sort of explain the behavior maybe a little bit better than if they just needed to maintain overall public support. And again, I think that maybe this decrease in public support is driving some of this lack of high profile cases, but ultimately the support for the court is at its lowest levels that it has been in decades. But among Republicans, it is the highest. And so that could help explain the sort of distinction between what we're seeing and how the court is actually behaving. So I guess that's a long-winded way to say that how the court responds is anybody's guess, but that's my hunch.
It'll be exciting to find out. So we have a couple questions already in the chat. You guys have made my moderating job really easily. We're under time for the main portion, so we have a lot of time for Q&A. You're also welcome to raise your hand using the Zoom raise hand function, but we'll start right now with questions in the chat. So the first, and anyone's welcome to take this one, is it likely that any justices will retire in the next 4 years? I'm sure that depends on the outcome of the election. And I guess we'll consider either outcome who would retire.
So I can,
Tim, go ahead.
Okay, so I will say that, let me take on Trump winning the election first. There'll be an interesting dilemma for at least one justice, and that's Justice Thomas, who made it clear he was going to sit on the court for 40 years. And 40 years would not be until 2031. And that was to really be a thorn in the side of any liberal who was against him during the very difficult confirmation process that he had. But let's assume that Trump wins and that Thomas and then in turn Alito, who are both going to be in their mid-70s by the time this term ends, would both leave. The interesting fact here is that that would allow President Trump, again, if he is going to be president or a second term, it would allow him to have 5 justices on the bench. And only these other presidents have done that in history. Eisenhower, FDR, Taft, Grant, Lincoln, Andrew Jackson, and George Washington are the only presidents who have ever had a majority of justices be their nominees to the bench. And so you go all the way back to the 1950s, where Ike had 5 appointments to the bench. That would be something that really is, for lack of a better term, simply historic for Trump to be able to have remade the court in that way. He's already remade it with the appointee, the 3 that he has had, with decisions, not just in Dobbs, but in many other issue areas. And I do think Nathan brought it up that I think that, on the other hand, if Harris wins, I think there will be a lot of pressure over the next, whatever it is, 45 days to have Sotomayor give up that seat.
So I would just add, I think we have to take very seriously the possibility that the era of cross-party Supreme Court confirmations is behind us. And that it's not just about who wins the presidency, but who controls the Senate. If Kamala Harris wins and the Senate and the Republicans control the Senate, I'm sure they'll say we're happy to consider nominees who we approve of, but any nominee who is a Democrat will not meet that test. And I think the problem with the Garland contretemps in 2016 is that if there was a lesson to be learned, it was that the parties don't face political consequences for, abdicating what I would think of as their institutional responsibility. And so long as that's true, the politics are going to be what they are. So it's not just to me about who's the president. It's about the real alignment of the presidency and the Senate. And I'll just say, I will be very surprised if there are any voluntary retirements during an unaligned era anytime soon.
Well, and if I mean, Nathan, I don't mean to cut you off, but let me make one quick point. And that is, I think the interesting thing will be whether or not the Democrats, let's say it's a Trump presidency and the Democrats do somehow actually take the Senate, whether or not they are willing to play that game, because the Democrats have largely been the party that has said, we will stick to institutional norms and rules. We will allow presidents to nominate. We will go through the entire process. Maybe we won't confirm, but we'll go through the entire process. I would expect the Democrats to act differently in a Trump presidency and Democratic Senate than in a Harris presidency and Republican Senate. Now, maybe the Democrats will finally decide that they want to act the way Mitch McConnell has and the Republicans, but time will tell, and I wouldn't hold my breath. Sorry, Nathan.
No. The only thing I want to add is that historically, in the lead up to the 2016 election, Senators Ted Cruz and John McCain said that they would be open to never confirming a Clinton nominee had she won the election. And this was after the death of Justice Scalia. And so going into that election, Republican senators who were pivotal votes were leaving open the possibility of keeping the seat open indefinitely, which effectively is shrinking the size of the court. And so I think if that situation arises again, where there's an involuntary vacancy on the court and the Republicans control the Senate, and the presidency is controlled by Democrats, it wouldn't surprise me a bit if Republicans were like, we're just not touching this until the next election.
Well, and Senators Cornyn and Thune have already said as much, right? That they are not sure, and they're the 2 most likely to be majority leader, that they're not sure they would allow that to happen. So they've already played that game, that card this time around as well.
Good. And that question was from Brianna. We have another really good question from Anthony. And he asked, I was wondering if Stephen could explain a little bit more about why it would be awkward for the conservative justices under a Trump administration.
Sure. So there's a ruling from this January that I think will help to put all this into context. So in January, the Supreme Court, on the emergency side of its docket, handed down a 5-4 ruling that, in a nutshell, basically cleared the way for the Biden administration to continue removing razor wire that Texas Governor Greg Abbott had placed along the U.S.-Mexico border. It was an emergency application. There was no majority opinion. There was no dissent. And so there's a lot of confusion, or there was no dissenting opinion. So there's a lot of confusion about what the court had actually held. Within a couple of hours of that ruling, Texas Congressman Chip Roy was on Fox News urging Governor Abbott to defy it. And, that did not get a lot of attention nationally, but I think that was actually like a five alarm sort of warning to the Supreme Court that, for as much as the court's defenders are currently criticizing people like me, right, for trying to sort of suggest that the court needs to be reformed, I'm much more worried about the specter of a court that does something that Republicans don't like, right? And that Republicans then say, let's just ignore. And, Chip Roy literally said that in January. J.D. Vance, the vice presidential Republican nominee, has talked about that on the campaign trail. And so, my concern is like a court that is worried about that is a court that is very possibly going to sort of hesitate before standing up to President Trump in a case that matters, is a court that is, I think, going to worry, right, about sort of its ability to do that. And, Christine, part of why people like me harp on the importance of the declining public faith in the court that we've been talking about is because that's its exact effect, which is the less public faith there is in the court, the fewer people there will be to stand up for the court when the next Chip Roy comes along. And I think that's a much bigger likelihood in a Trump administration than in a Kamala Harris administration.
And if I may, Christine, and I've talked about this to my students recently and some other folks who've asked me about this exact question. I was asked, it's probably been 15 years now, to write an editorial that was a group of editorials from legal scholars and political scientists about whether or not the Supreme Court was partisan. And at the time, even in 2010, I was still making the argument, as political scientists do, that the court is always been ideological. The court was highly ideologically divided by 2010, but that the court had never been divided in a partisan way, and that has actually changed. And if I was asked to write that exact same editorial now, I would make an argument that there is actually partisanship that has seeped in great ways, actually probably in great waves, to the U.S. Supreme Court. And so I think Steve is spot on. I mean, this idea that Steve asking and others asking for reform is itself delegitimizing the court. Political scientists know we've gotten that argument since 1948, since C. Herman Pritchett said the court is actually ideological. And people said, if the public knows it's ideological, they will not support the court. We know that just was not true. And did not happen empirically, but I think it's this idea that the court has now become so highly partisan and not just ideological that has been what is tearing down the walls of the court's legitimacy. And so I commend Steve and others for doing this, to making these arguments.
So speaking of a partisan court, we have a great question from Elizabeth Lane about the Fifth Circuit. So lots of spicy takes here, I'm sure. So she says the Supreme Court was quite clear about how they feel about some of the more extreme rulings coming out of the Fifth Circuit. And for the undergraduates, the Fifth Circuit is known to be a fairly conservative leaning circuit. She asks, do we think attorneys are using this circuit strategically to advance their policies, and will that continue? Or do you think the court's actions have made it clear that they disapprove of that behavior and people will stop flooding the Fifth Circuit with that type of litigation?
I think this one's for me. So I'm pasting into the chat. I wrote about this for my newsletter. So to make a long story short, because of nerdy venue rules in the federal courts, it is possible, if you're challenging nationwide policies, to actually be pretty savvy about where you're going to bring the challenge. And because of quirky old historical things about Texas geography, it is possible to not just steer cases to Texas, but steer them to individual federal judges in Texas who you know in advance. And so this has led to an uptick in what some folks like me call judge shopping, which is different from forum shopping. Forum shopping is when you file in a courthouse or a district where, in general, you think you have a better shot with the law or all of the judges or the jury pool. Judge shopping is you file somewhere where you have a 100% chance of drawing a particular judge. And we've seen a lot of that going on in Texas because that's where there are the most of these so-called single judge divisions that I talk about in the newsletter. So the Mifepristone case was filed in Amarillo because there was a 100% chance it would be assigned to Matthew Kaczmarek. The social media jawboning case was filed in Monroe, Louisiana, because it had a 100% chance of being assigned to Judge Terry Downey. Is this going to continue? So the short answer is it depends on two things. The biggest thing it depends on is who wins in November, because the judge shopping right now is all right-wing litigants shopping for anti-Biden administration rulings. And one of the most common litigants doing that is the state of Texas, which has now filed, by my count, 50 different lawsuits challenging Biden policies, 0 in Austin, which is where, the state government is. In a Trump administration, Texas will not be suing the federal government, right? California will, but there aren't the same kind of single judge divisions in California. So thing number one is who's going to be the president, and then which courts are we going to see used for those purposes? It won't be the Fifth Circuit if it's Trump. Then number two is, this judge shopping has become so transparent and so shameless that it's actually provoked calls for reform, even from folks to the right of center. The Judicial Conference of the United States, which is the policymaking body of the federal courts, recommended in March that courts, which currently, right now, all the district courts can choose their own case assignment rules. The Judicial Conference recommended that courts stop the practice of single judge divisions. They could not force the courts to do it, and the Northern District of Texas did not. But the more this happens, I think the more pressure there will be on Congress to actually rewrite the relevant statutes, either to require randomization or to make sure that certain of these lawsuits have to be brought either in Washington, D.C. or before special 3-judge district courts. But so, the short version is the Fifth Circuit is going to continue to have all of the power it has, right? So long as there's a Democratic president and no reforms to the venue rules. Because even though the Fifth Circuit keeps getting slapped down by the Supreme Court, that doesn't seem to be stopping it. And it's not just, Christine, you were generous. I would say it's not just conservative judges. The Fifth Circuit has judges. I mean, we're at a point where the median judge on the Fifth Circuit, which covers Texas, Louisiana, and Mississippi, is pretty far to the right of the median justice on the Supreme Court. And that's a lot of what we're seeing in the relationship between those two.
Are there any other questions? Or Tim, you can go ahead.
Yeah, so if I may, I mean, beyond the reforms that Steve's talking about, and I think that they're fully appropriate. If you imagine a world in which Harris wins, the Democrats retake the House, and they're able to hold the Senate, right? I mean, that's a lot to ask, but let's just assume that happens. I could see the Democrats doing what happened under the Carter administration and simply creating new judgeships, not only reforming, but creating new judgeships at the district court level, at the circuit court level, so that they can try to mitigate some of the effect of all of the Trump appointees. Because remember, it's not just the 3 on the Supreme Court that have changed the ideological direction of federal courts. It is the massive numbers that President Trump was able to have confirmed in the circuits as well as on the district courts. And I will tell you that most judges and most justices would rather not have it be the case that we've gotten so partisan and ideological in those lower courts for not just the forum shopping, but the judge shopping. And I will give you just one quick example, and that was during the Clinton administration. There were so many open judgeships because the GOP Senate was not willing to confirm Clinton appointees, that Chief Justice Rehnquist, as head of the Judicial Conference, went to Congress and said, we don't care if these people are more liberal or moderate than you might like. We need bodies in the circuits and in the district courts to actually hear cases and get things done. So I think reform is probably going to happen. And I think there are judges and justices who are asking for that reform, but you're going to need the right combination of who's running the elected branches for that to happen.
Nathan, I'm going to abuse my position as moderator and ask you if we ran some surveys on judicial reform right now, what do you expect we would see? It might be you already have one in the field or working on something like this.
I do not, but historically, the public has generally been pretty receptive to reforms. So breaking them up into 2 camps. So things like term limits, mandatory retirement ages, things like that are generally popular among the public, and they have been for decades. Reforms like expanding the size of the Supreme Court still are unpopular. That is an unpopular reform. But I think one of the things, going back to what I mentioned earlier, with all of this, it's really going to depend on the ability of Democrats, particularly, to stay on message and to keep this issue on the public radar. So, like the ethics scandals that we've had, there have not been much discussion of it in the last month or two among Democrats. It's not been talked about on the campaign trail that I'm aware of. In 2020, President Biden said that he was going to create a commission to, study it, reform of the court, and he did. And so it was a big issue in that election. This year, Vice President Harris on the campaign has said that she's open to the idea, but it has not been part of her stump speech, I don't think. And so it's going to come down, and especially on these sort of nerdy procedural questions. Like, I think if you ask the public, should somebody be able to choose their judge as opposed to randomly have it assigned, they're going to say that it should be random. And that it's unfair to be able to pick this judge for this particular reason. It's just very hard to convey that to the public in a way, because most people are not like us and spend their Fridays on webinars about the Supreme Court. And so it's really going to depend on the parties to keep this in the forefront.
Okay, great. We have time, I think, for one or two more questions. And I really like this one. The circuits have been restaffed by the last two presidents. And so some of their reputations are a little bit different. The Ninth Circuit looks very different now than it did 10 years ago. And Susan Olson asks, are the new Biden appointees to lower court seats, district and circuit, are they having much of an effect? Are they able to do much? We haven't talked much about Biden's pretty generously sized number of appointees he's gotten through.
Yeah, I mean, generous, Christine, in the aggregate, right? The story gets more complicated if we drill it down. So even though the Senate got rid of blue slips for circuit court nominees, blue slips are still doing a lot of work. And the reason is because there are red state senators saying, we won't return blue slips for district court nominees, which we still have, unless we get some input into the circuit court nominees. And so at least from the Biden administration's perspective, the President Biden's been wildly successful in circuit courts that had both a number of open seats and a bunch of Democratic senators. So the Third Circuit, which is Delaware, New Jersey, Pennsylvania, and the U.S. Virgin Islands, although that's we don't really worry about that. Right, the Third Circuit looks very different. Right, the Ninth Circuit, Trump's appointees had swung it almost to the right of center. I think the Biden appointees have swung it not back as far to the left as when I clerked there 20 years ago, but still left of center. So the Second Circuit, the same. So I think that there are some courts where President Biden's appointees have had a huge effect. But then there's the Fifth Circuit. I mean, President Biden has had two appointees to the Fifth Circuit. And I don't, I like them both very much as judges. I don't think anyone would say they've had much of an effect. Right. And so I really think it is the impact of the Biden lower court judges has been very geographically uneven, where you can point to lots of examples of impact, but also some states where it's been very, very modest. Sorry, I should just, the one place where I think President Biden has been unprecedentedly successful is in the sort of diversification of the federal bench. And we'd be remiss in not pointing that out, that this is a much more diverse federal bench, not just from the perspective of, racial and ethnic diversity and gender diversity, although that's true, but experiential diversity. There are a bunch of federal public defenders who are now federal judges. That was not even under prior Democratic administrations a priority. So, again, where President Biden has not hit resistance from red state senators, I think he has really had quite an effect, both substantively and demographically. But mostly in those parts of the country.
I think the last time I looked at that data too, there's more law schools being represented on the federal bench now than there were before, which is a good sign. Any other lingering questions from the audience or things that came up for the panelists that you're just thinking about as part of this conversation?
One thing that I would just want to say in response to what Steve said, I agree everything. But in addition to the red state senators, it's also moderate Democrats. So, for example, Joe Manchin refusing to vote to confirm any Biden nominees unless at least one Republican signed on. So, like his own sort of mini filibuster, which I think I could be wrong, but I think he did break that a few months ago. But he was very adamant that, he's wanting to be bipartisan and support the institutions, and he was not going to support and to confirm any Biden nominee unless at least one Republican senator joined him in supporting the nominee.
Great. Well, we are at 1:30. I want to say thank you again to our panelists. This was super useful. And I am excited about the attendance for this first webinar, and I hope to see all of you again the next time. So thanks again.